Right. It is about 10:35. I think it's appropriate to get started. Um, we have the opportunity to file an amicus in Carney v. Adams. It is a Supreme Court case regarding whether or not a state can require judges to be from one of the dominant political parties in the state. Third Circuit found it unconstitutional, and the Supreme Court has granted certiorari, which is, at least on its face, not great for our side, because they don't need to grant cert if they're going to just let it be unconstitutional. So it could be good, but it's probably not. And Oliver had sent out a summary of the case to the business list, and there was a little bit of discussion, but we're getting to the point where we need to decide what to do. So Oliver, do you want to go back over anything that I might have missed, or kind of outline what the options are for the executive committee?
Mr. Chair?
Yeah, sorry.
Just would like to note that Dr. Lark has joined us.
Yes, sorry, I should have said welcome, Dr. Lark.
Thank you.
Sure. I mean, I think the main points are laid out in the written proposal that I sent. And you know, at this point, time is rather short. The deadline for filing a brief is March 2nd. Nonetheless, I don't think it's impossible to prepare and file a brief in that time, especially if it were limited to one or two discrete issues that I've noted here. I mean, potentially, well, anyway, I think there are one or two discrete issues that the LNC could be very effective in addressing, and is perhaps uniquely situated to address. The point that resonates with me personally, and I think is also strong in a legal sense, is the idea that this categorical exclusion of anyone who is not a Republican or a Democrat from serving on the most important judiciary posts in the state of Delaware, you know, is clearly unconstitutional, in violation of Libertarian and other non-Republican or Democrat citizens. And you know, I don't think anybody would have any doubt as to the unconstitutionality of these provisions if, instead of saying you had to be a major party member to serve as a judge in Delaware, you had to instead be a member of the Libertarian or Green Party. And I think that sort of comparative argument is the sort of thing that the LNC is somewhat uniquely situated to make, because other than the Greens and the Libertarians and, you know, any other minor party or independent person out there, no one else is in the position of being able to say my rights are directly violated here. And it's a compelling argument because anybody can see on its face that the categorical exclusion of someone from participating in a government post like this based on nothing more than political affiliation is a clear violation of the First Amendment rights of that individual. And nobody would ever suggest that it would be permissible if the individual were a Republican or a Democrat. We're only here because the plaintiff is something other than one of those two parties. And so this is not an area of the law that I have specifically dealt with, but I have been reviewing some of the briefs in the case, and clearly there are associational rights cases that could be cited and expanded upon to make that sort of argument. I think with respect to the logistics of how a brief might get filed if it were approved by the executive committee, in addition to the two options that I mentioned at the beginning of this call, it's been suggested that the Cato Institute is also filing an amicus brief in this case, and that we might reach out to them. I did do that in a recent case where they were filing an amicus brief, and we offered to join their brief and they rejected that offer, and maybe that would happen again. But again, the LNC, I think, is in a sort of a unique role in this case, in being able to bring the perspective of individuals who are directly harmed by this, by these constitutional provisions of the Delaware State Constitution. So they may take a different view of the matter in this case.
Oliver, just can you summarize for Sam and others what the cost would be if we went with the author who would do it pro bono, but have you as lead counsel for the record, like kind of what that cost would likely be?
Well, to be clear, that would require me to actually write the brief.
Okay.
It's not something that I would rule out categorically right now, because I think that this case is important, and I think it would be worthwhile for the LNC to file a brief in this case. But I just, my time is very limited between now and the 2nd, and before I committed to that, I would at least need a day to confer with a couple of colleagues, both about the case, in which we would be filing the brief, but also my other commitments. So I wouldn't want to commit to that on the phone tonight.
Yeah, and I was not trying to be assumptive. I thought that was I thought that was a different option, I think, than I made it sound like.
The offer from the 2 pro bono attorneys is to provide some kind of support in the event that we can find an attorney who is the lead attorney. And honestly, at this point, I'm not sure how helpful that would be, because collaboration itself takes some time and coordination. And if we're doing just a short brief on a discrete issue or two, it might be simplest for a single person to handle it.
Is there anyone who has any questions?
Mr. Chairman, this is Jim Lark.
Go ahead.
Question for Mr. Hall. First of all, Mr. Hall, thank you for the material that you've provided to the executive committee. Again, I guess the only issue I have is that we are in an election year. Resources, while we're not extremely tight, this is an election year. We have limited resources. And I guess my question is, how much good is an amicus brief from us going to do? Is this something that if we don't provide a brief, that it's going to change substantially the odds? Of course, obviously, you can't say with certainty. I'm inclined to say, actually, yes. Let's file if we can get something decent done. And if the executive committee, indeed the LNC, can actually review what's being done before it's actually submitted, I would be inclined. But I guess my question is this something that if it's not done, is it really going to make a difference?
Thank you for your question, Dr. Lark. To make a prediction like that with any sort of specificity, I think, is inherently speculative. What I will say, though, is I think as far as filing amicus briefs for or against the merits of a case before the Supreme Court, in this case, it would be helpful and is important for at least 2 reasons. One is the brief of the respondent, who is the independent candidate who won in the proceedings below, is not as strong as it could be. It doesn't clearly, I think, address the issues, and in particular, it doesn't clearly make the kind of First Amendment arguments that the LNC might make in a separate amicus brief. So I think that the respondent could use the support of Amici, like the LNC and others. And then secondly, there have been many amicus briefs filed in this case already, and unfortunately, they are all lining up mainly on the other side. Groups like the Brennan Center and others, so-called good government groups, have been filing briefs in support of these Delaware state constitutional provisions on the ground that they promote diversity among the judiciary. And clearly,
Mr. Hall, if I may interrupt you, I must say I'm very surprised to hear that the Brennan Center would be so disposed. That's very interesting.
surprised and disappointed, I might add. They cannot have failed to notice that a constitutional provision that requires membership from only 2 of the political parties in existence, therefore categorically excludes all others, which is a clear violation of core constitutional rights of anyone who's not a Republican or a Democrat. They must know that, and yet they're still lining up in support of the petitioner in this case. So clearly there's a subtext going on. Delaware courts, I think, occupy a uniquely important role in the United States because that's where essentially all corporate law gets done.
Yes, sir. Yes, sir.
And so that may be a third reason why this case is particularly important. But I agree with you that,
Mr. Hall, you just answered my question. I thank you very much. That was very informative.
Thank you.
Mr. Goldstein?
Mr. Hall, if I was to propose a motion that the LNC spend no more than $5,000 on this amicus, would that be adequate?
In my opinion, Mr. Goldstein, it would be, because I would hope that we would find an attorney to work pro bono or quasi pro bono, and if my estimate of about $1,500 for the printing costs is accurate, then that would leave a reasonable sum for a fee for the attorney who does the work on that basis.
And the due date is March 2nd, right?
Correct.
If I was to add a proviso that said brief be submitted to the executive committee no later than the 28th, would that give adequate time to find somebody to have them write the brief?
I just don't know. I don't know, but I think that that it's reasonable to request a reasonable amount of time before the filing deadline for the LNC to review the brief. So if that is something that you would want to impose as a condition, I think it would be understandable to anybody who would be willing to consider the case.
Then I think I'll go ahead and make that motion. I move that the executive committee approve no more than $5,000 from the whatever line budget item the legal offense fund is to file an amicus brief in this case, and with the proviso that the finished brief be submitted to the executive committee no later than February 28th.
Mr. Goldstein, your mic is cutting in and out,
Nope.
And I only got,
Yeah.
yeah, could you please restate your motion? Because I've got every other word.
I'll bring it up closer. I move that the executive committee appropriate no more than $5,000 out of whatever the appropriate budget line is to solicit an attorney and file an amicus brief in this case, with the proviso being that the finished brief be submitted to the executive committee for review and approval no later than February 28th.
Okay.
Mr. Chairman, I will second the motion.
You moved and seconded. Mr. Goldstein, do you need to speak to the motion?
I don't believe so. I think it's been answered adequately.
Okay. Would anyone else like to speak to the motion or against the motion, or does anyone have any other questions? Hearing none, I think we're prepared to move to a vote. Go ahead, Ms. Harlos.
Mr. Goldstein?
Yes.
I will vote yes. Dr. Lark?
Aye.
Mr. Merced?
Yes.
Would the chair like to vote? It's 4 yeses.
I'll vote yes.
Okay, 5 yeses, no nos.
All right. And then I think that's everything for this evening. I will work with Minister Redpath to deal with what's going on in Iowa. And that, will probably just be in the normal business of the office unless there's a budgetary change that needs to be requested. And with that, unless there's anything else people have, we can be done with our meeting.
Mr. Chairman, as always, I'd like to thank Mr. Hall for his work on behalf of the Libertarian Party.
Thank you, Dr. Lark.
Thank you. And I will add that I will get to work on this right away and report progress in terms of options and what's shaping up as soon as I can.
Thank you, Mr. Hall. All right, we will be adjourned. Thanks, everyone.
Thank
you,
you.
Mr. Chairman.
Everybody.
Good night.
Okay.